Hello and welcome to this evening's Solidarity session on Palestine. This is our five-part series for 2025. Tonight, we're going to have an update on international law in Palestine from John Reynolds, Dr. John Reynolds in Maynooth University. My name is Tom Lonergan. I'm the education officer with IPSC. And also on the call is Brian O'Hagerty, who is the media officer from IPSC. So tonight, as I say, this is a part of a five-part series. So this is our third one, third Monday night. So on the first Monday night, we had a presentation on the central bank still funding genocide. Last Monday night, we had Iman Mohammed, a Palestinian photojournalist, giving her experience, and that was very interesting. Tonight we have John. Next week we have Dr. Rebecca Heslin, a clinical psychologist. I'll speak about that a little bit at the end. And on the final one, then we have Zoe Lawler and our chair and Brian presenting on the priorities in Ireland and the media issues relating to Ireland. So I'd like to welcome Dr. John Reynolds tonight. For this session on international law in Palestine, an update on the ICJ and ICC cases. John is Associate Professor of Law and Criminology and in Maynooth University. He's an expert on international law. He's a member of Academics for Palestine. He's an international lawyer. And John has an extensive, really extensive career and in terms of presenting research, presenting papers, working on cases. He has a book from 2017 called Empire, Emergency and International Law. He's a founding editor of Third World Approaches to International Law Review Journal. So John, I'm going to hand over to you and I'm going to stop sharing my screen. You're most welcome and I'm looking forward to your presentation.
Thanks very much, Tom, and thanks to the IPSC for these important series of sessions, and especially thanks to everyone for being here on a fairly miserable Monday night. So I will I'm just going to throw up some slides here. There's nothing really in them in terms of information. It's just a few images, but it's mainly just to keep myself on track. So let me just see if that's working there. Hopefully you can see that, but let me know if not.
Yeah, we can see that, John.
Okay. Grant. So as Tom said, I'm of an international lawyer of sorts. For people that don't know me, I study international law, I teach international law, I write about international law, but just to be clear, I suppose that I'm not here as any kind of spokesperson for on behalf of international law or kind of hardline defender of it. A lot of my work is very critical of international law and its limitations, its blind spots, some of its structural biases and dark colonial history and continuing imperial tendencies and all of that, but it is an important space on site of contestation, and one I think that increasingly global South countries and movements and places like Palestine, and also through initiatives like the Hague Group, which we can talk about later, are trying to engage with and ultimately transform international law in the face of what's now a fairly full frontal assault by the US and the likes of Israel. And so look, and we do have to remember, I suppose, that a settler colonial state like Israel is not going to voluntarily comply with rulings against it by international courts, and the real question of the enforcement of international law is about how willing other states are to coerce a violating state like Israel into some measure of compliance. And so, when we have a ruling or a decision from an international court or tribunal or institution that, will confirm and apply the law to the facts at hand, but it's ultimately up to the UN member states to enforce it through their bilateral and multilateral relationships with states like Israel. And I'm sure people are very well aware that like there's all too many Western states really who present themselves as liberal supporters of international law, but who have not been doing nearly enough to impose the types of sanctions and material measures that are needed to push Israel to stop its genocidal atrocities, to end its occupation and apartheid regimes. And so it's up to us as activists, social movements, campaign groups, legal action groups, opposition representatives, and all of the wider circles to push governments and states to do that really. And so I'm sure everyone that's here will be, you'll know and be familiar with the reality that Ireland hasn't been doing what it can and what it should. And so we can talk a bit as we go through it and in discussion at the end about what Ireland should be doing as a bare minimum to meet its own legal obligations under the general kind of rules and framework of international law and under some of the specific decisions that are coming from the International Court of Justice or the International Criminal Court. And so I'll try to give a bit of a summary, as Tom had asked me to do, on some of the updates coming from those institutions and where things are at with the different processes. I think the last session of this type that I did was around the summer of 2024. Some of you may have been at that, others maybe not, but a lot has happened in many ways. In the meantime, there have been various developments, but obviously overall, nothing significant enough has happened to stop the scale of the atrocities, the slaughter, the starvation in the meantime. And we're in this difficult situation now where there's the pretense of a peace plan and so on in being imposed and uh, a certain kind of quite neo-colonial vision of some kind of transition process for Gaza, but that's also been used quite conveniently and strategically by the European Union, UEFA, and the sporting bodies, other, any institutions that had any momentum or movement towards even limited or partial sanctions against Israel has been now stalled, and there's this deference to, oh well, let's see what happens with the peace process. And so, and the the peace, I suppose, just to emphasize the peace plan. um there's major kind of gaps and problems there in terms of basic questions of international justice, accountability, reparations, and so on before we even talk about the kind of problematic elements of the US's involvement and construction of military bases and the continuing occupation of Gaza and all that. Um, so we might come back to some of that, but yeah. So since 2024, there's been a few developments at the International Court of Justice. So I'll start there, and the South Africa versus Israel case is probably the one that people are most familiar with or were following. Um, as it went along through early 2024, we had those series of three different provisional measures orders from the court in January, March, and May 2024, each taking a kind of a more um, a clearer stance on what Israel was failing to do in terms of its obligations not to perpetrate genocide, to prevent genocidal incitement in the public sphere, all of that, which and by May 2024, this order from the court that Israel had to halt its military offensive in Rafah, at least in Rafah, may potentially also more broadly in Gaza as a whole, depending on your interpretation of the order at that time. But Israel responded, by carrying out some of the worst atrocities of the entire 2 years of genocide in Rafah straight after that, with the tent massacre in the safe zone there, and this horrendous bombardment and firebombing of the camp there in the 48 hours after the judgment was handed down. So we had a very clear kind of message and signal from Israel that it wasn't going to comply at that stage. And so then, the question is what has happened since then and where things are at now. So basically, that was May 2024. That was the last of the provisional orders, which were about trying to prevent genocide, whatever about the court's final decision on whether and to what extent and in what ways genocide has or has not been perpetrated by Israel. That the court has that scope for the provisional measures to try and halt the situation before it's getting worse. South Africa then had a time period to submit its full memorial, as it's called, like so its full detailed set of arguments and evidence in the case, which it had to submit but by October 2024, which it did. And I know just from talking to some colleagues on the South African legal team, like the amount of work and energy and all hands on deck efforts to get that memorial in, which ended up being, I think, 750 pages of evidence and legal argument, and then another few thousand pages of supporting material. So to get that all in on the deadline at the level of quality and detail and depth that they wanted to have it at was a huge effort. They did that. Israel then had a similar period to file its counter memorial, as it's called, and the deadline for that was July 2025. Um, Israel ended up asking for an extension on that and being granted an extension by the court till the end of this year, the end of 2025. And then just last month in October there, Israel went back and requested another further extension for another 5 months, which South Africa very strongly argued against and asked the court to reject on the basis that, Israel's already had one extension for the same reasons that it was trying to ask for this one, that it needed more time to study the documents, etc., etc. But South Africa was trying to insist on the urgency of the case and the issues on the ground, that this has already been delayed too much. But the court ended up granting the extension to Israel, so they now have until March 2026 to file that counter memorial. Assuming they do that by then, which we still don't know for sure if they will, but assuming they do that by then we'll be into the next phase of it, which could and most likely will involve some preliminary objections by Israel on elements of the South African claim, which will then require a round of hearings and a judgment on those preliminary objections by the court. Assuming the court dismisses the preliminary objections, then you get to the final stage on the judgment on the merits. And so, that's realistically not going to, any final judgment in that case is realistically not going to be before 2027 at this stage, and, possibly even later again, depending on how things go. And like my sense of why the court is indulging Israel with granting these extensions, I think there's it's probably partly, at least, out of some concern that Israel may ultimately decide not to fully participate through to the end and may try to withdraw from the case and then use that as a way to say that this was biased or unfair against them. That has been something that's been a feature of Israeli engagement with other international courts and human rights bodies and so on, to disengage and then to accuse the institution of bias or one-sidedness. And so, it has up to now, and the International Court of Justice does have a particular gravitas that other even international courts and tribunals don't have. But we'll see. We'll see what happens there. I suppose one thing, because obviously the slowness and the lack, the lack of urgency of the process in juxtaposition with the absolute urgency of the situation on the ground is quite jarring and quite hard to get our heads around a lot of the time. But again, I suppose I would just try and emphasize that there were important things set down in the provisional measures order, and states don't have to wait for a final decision on the court from the court to take action to prevent further genocidal atrocities from happening. Colombia and states like that have done that and have used and invoked the ICJ rulings so far as the justification for implementing, in Colombia's case, for example, the coal embargo that it's introduced on against Israel, and so there is plenty of scopes for states that are willing and able to do so. There's been lots of other findings by all of the main human rights organizations, by the leading associations of genocide scholars, by UN fact-finding commissions and commissions of inquiry, and so lots of authorities with serious credentials have, in the meantime, found definitively that Israel is and has been perpetrating genocide, and so the final decision from the ICJ will be important and will be significant, but it's there's an imperative to also act according to international law in the meantime as well. Um, one side note on that, and I know there was the previous webinar a couple of weeks ago with Helen and others on the Israel bonds issue, but um, it is just a point to note here as well, just in thinking about the Irish context, like the argument, as I understand it, of the central bank is that as a central bank, they don't have any obligations or commitments or responsibilities under international law, and international law has nothing to do with them. But if clearly there's like a strong body of material and uh, argument about the nature of the obligations and responsibilities of states under international law, and that's not, it's not the obligations and responsibilities that states have are not only those of the executive branch of the government or the leadership of the state at the highest level of government. State agencies of various kinds, public bodies, uh, local councils and municipalities. There's a whole kind of range of layers and levels at which state obligations kick in and do arise. And the central bank, yes, it's an independent body, as in independent of the executive branch of the government for the particular reasons of its function in terms of the economy and the fiscal situation. But it is still a public body, and there would be many international lawyers who would argue that central banks and institutions like that can't say that international law is irrelevant to them, where they're carrying out functions that do have an impact in terms of duties, state duties under the Genocide Convention to prevent genocide, and which includes preventing the funding and financing of genocide. There are obligations that are relevant there. So again, just to note, I suppose, that questions about responsibility under the Genocide Convention, the duty to prevent genocide, the duty to punish genocide, all of that comes up and is relevant, and does needs to and should be playing out through state policy, through other legal interventions, regardless of how long we have to wait for a final decision from the ICJ, and just not to um, uh, um, discourage people any more than I already might have done already, but just, I suppose, to um, flag that in the Bosnia versus Serbia genocide case, it did take in the end 14 years from when the case was first filed by Bosnia in 1993 until there was a final decision and judgment on the merits from the ICJ in 2007. And so at that point, really, obviously it's too late to stop a genocide, but it's about reparations and accountability. But in the meantime, there's lots of other important parts of the process that should be continuing, and it's not acceptable for states or universities or anyone else to say, well, we can't make a statement on this or take a position on this or engage on this because we have to wait for a final decision from the ICJ. There's plenty of other authorities who've weighed in the meantime. Okay, so that's on genocide. The couple of other International Court of Justice opinions that have come up in the last 2 years as well. People, I'm sure, will be familiar with this, so I won't kind of dwell on it too much. But the advisory opinion from the summer 2024 on the illegal occupation and Israel's unlawful presence in the Palestinian territory, and the ruling from the court there that not just individual aspects of the occupation, like the settlements or the blockade of Gaza or particular bombardments. It's not just that those component parts of the occupation were themselves violations of international law, but the entire occupation was found to be unlawful and in breach of international law overall. And so that was, in some ways confirming what a lot of international lawyers and other authorities have been arguing already, but there was an uncertainty because occupation in and of itself is permissible in a post-conflict temporary transitional context, but where you have an occupation that's essentially indefinite or permanent in the way that it is in Palestine, and that has all these features of racial discrimination and apartheid and segregation and these very embedded structural and institutional violations. The court said, the occupation in and of itself is illegal and must be ended as rapidly as possible. And it also set out for third states and member states of the UN, what their obligations were to do to bring that forward, including ceasing any trade and economic and investment relations with Israel that in any way sustained or supported the illegal occupation regime. And so there, I suppose the key point is that um, that's about any trade or economic relations with Israel that connect to the occupation. It's not just the occupied territories or the settlements. And so we can come back to that maybe and talk about just the implications of that for thinking about the occupied territories bill here. But I suppose the key point to that I would emphasize now is that the passing of the occupied territories bill in its fullest form with services included, that would actually only be the minimum starting point needed to bring Ireland into compliance with the International Court of Justice advisory opinion on the occupation, and it would actually need to go beyond that because of how integrated the occupation is with the wider Israeli economy. Um, okay, we can maybe, I'm sure that, we may want to come back to that, but that was on the advisory opinion, and that's a year and a half ago nearly. We're in this kind of absurd position that we see with some states who are like, there was a question in the British Parliament recently put to one of the government ministers about what the British government is doing to bring itself into compliance with the ICJ advisory opinion. And the answer from the minister was that we're still studying the ICJ opinion closely, and basically deciding, what we have to do about it. And so, a month and what are we? That's like a month and 4 years later that they're saying they're still studying it. So, I just think it's fair to say at this point that Keir Starmer's government are, essentially trolling people there with that type of response. And the European Union position on it is even more absurd in some sense, like specifically on the question of settlement trade and the obligations of European members on that. Like, there was this joint letter by 9 member states that sent over the summer to the European Commission, including Ireland as one of them, about what is the EU doing, what's the EU Commission position on this, and the Commission response was that the European trade policy at the moment is fully in line with the July 2024 ICJ ruling, and therefore there's no need for taking action on banning trade with the settlements, which is an absolutely absurd position for them to take, and in no way uh, supported by what the advisory opinion actually says. And again, really, really disingenuous in many ways. And so that creates then this whole contestation over enforcement of some of the most basic elements of international law, the colonial settlement in a occupied territory or a territory that's not part of your own sovereign state. That the colonization and conquest and settlement of that territory should not be allowed, and that no other states should support that. There's still states reluctant to actually accept that or act, at least to act on it. And so you have, that's creates then the need and the impetus for, say, Francesca Albanese in her last report on, as Special Rapporteur on Palestine, on the responsibilities and complicities really of states, of corporations, and other entities who are still continuing to engage in all of this business as usual with Israel, despite what the highest court in the UN system has made clear as, a very some kind of very basic principles of law. And so then, that's back to then the question of the role of activism and needing to push the states beyond what they're willing to do voluntarily. Okay, that was last year's advisory opinion. There was another advisory opinion this year, separately requested of the International Court of Justice by the UN General Assembly, prompted by the whole move by Israel and supported by the US to try and delegitimize and defund and ultimately exclude UNRWA from its activities in Gaza particularly, but also in the region, in Palestine and the region generally. And prompted by that, there was a request from the UN General Assembly to the International Court about for the asking the International Court of Justice to clarify and set out what are Israel's obligations when it comes to the presence and activities of not just UNRWA, but the UN generally, UN agencies, and other international organizations in working in the Palestinian territory. And again, the court didn't reinvent the wheel or come up with any major kind of radical new jurisprudence or anything here, but it did just clarify the existing kind of clarify and restate the existing rules of international law when it comes to UN and international organizations work, the access that they should have, the diplomatic protections and so on that they should have, and applied that to the situation on the ground in Palestine, and said that Israel has obligations both as an occupying power of Palestinian territory, in control of the territory, and also as a member of the United Nations. And so it has clear legal obligations to facilitate relief and aid and humanitarian schemes provided by the UN and its agencies, including UNRWA. And it kind of set out a whole list of stuff that Israel had to do to respect and protect the relief and medical personnel and facilities, to allow for rapid and unimpeded delivery of aid and so on, and said that Israel wasn't doing that from what it could see, and that there was, it wasn't acceptable to be invoking security concerns to justify a blanket obstruction of humanitarian aid as Israel had been doing. And the court specifically kind of emphasized that, UNRWA has this indispensable role in Palestine, that it's deeply integrated into the humanitarian infrastructure, that it's because of that its work can't be replaced, and it is essential, it is providing essential services and is the primary provider really of essential services in Gaza that are needed. It said that the court said that it had saw no sufficient evidence from what Israel had presented that UNRWA had breached any impartiality provisions, and it said that Israel's allegations remained unsubstantiated. And so again, some strong language calling on Israel to respect and facilitate access for the UN, its personnel, for organizations like the International Committee of the Red Cross as well, and to carry out their mandates without interference. And it is importantly and kind of significantly as well, I think two other things just to flag. It criticized and expressed a lot of concern about the role of the Gaza Humanitarian Foundation, which was the kind of US-Israeli imposed alternative aid distribution process and mechanism, which ended up becoming the site of killing fields of Palestinians desperately seeking aid, as people will have seen. And it also said that UNRWA, because of its unique mandate and its formation in the context and the aftermath of the Nakba in 1948, that specific and unique kind of element about UNRWA was reflecting the UN's commitment to supporting the Palestinian people's right to self-determination, which remains a cornerstone principle of international law and an ongoing and fundamental one. And so it's not just UNRWA's role is not just about humanitarian aid, it's also about contributing to Palestinian liberation more broadly, supporting refugees, supporting the right to return of refugees, which really ultimately is why Israel has been so antagonistic and hostile and aggressive in its attacks against Israel because of, against UNRWA because of the association of UNRWA with the Palestinian refugee question and the right of return. And so again, some strong kind of restatements and reinforcements of long established kind of principles there by the International Court. That was just last month in October that opinion was handed down. The predictable response from the Israeli ambassador, immediately was that this was a shameful decision, and again, kind of trying to deflect by repeating some of its allegations against UNRWA, but not engaging in any way with the substance of it. So again, it's up to member states to enforce this and pursue it as robustly as they can in their dealings with Israel and in any kind of processes now that are being put in place in terms um, of new authorities, protection forces, the kind of stuff that's been talked about in the peace plan scenario stuff, that UNRWA and the UN agency still are the primary and most important resources there on the ground. Okay, so that's the International Court of Justice, the International Criminal Court, which I'm sure some people are very well aware, but just to be clear, is also based in The Hague, but it's a entirely separate institution to the International Court of Justice. It's outside of the UN system. It's constituted by its own member states, which are not all of the member states, which are around two-thirds of member states of the UN are also members of the International Criminal Court, but some significant states, including the US, Israel, and Russia, and others who are not members of the ICC, and that does make its own implementation of its own mandate more difficult. There's a huge amount to say and very little to say in some senses about what's been going on there over the past year or more. And so I'm just conscious of the time and leaving time for questions. So I'll just mention a couple of brief high kind of headline points here. If people do want to get into more detail on the ICC, I'm happy to do that in the discussion, but people will probably be very well aware that in around this time last year that the court did issue arrest warrants for Prime Minister Netanyahu and former Defense Minister Gallant as the two main Israeli perpetrators that had been named, and that the prosecutor of the ICC had asked for arrest warrants to be issued for war crimes, including the war crime of starvation and other serious international crimes. That those warrants were issued by the pre-trial chamber of judges of the court this time last year, and there's been this whole series of kind of diplomatic contestations over that. The US obviously and Israel not happy at all with that and saying that this is an outrage and that they're not going to accept it. Some ICC member states, um, including European states, some of the likes of Belgium, Slovenia, and many of the global South states, saying that this is an important process that the international community should absolutely support the ICC. And then you have those more powerful European states who are significant members of the ICC who've been quite at best equivocal and wavering, if not openly opposed to what the ICC is doing here in pursuing Netanyahu, the likes of Germany, Italy, France, Britain, who are, ultimately, even if they don't say it explicitly, are opposed to his arrest warrant being pursued, and any trial or prosecution proceeding, have been allowing him in some cases to travel freely through their airspace en route to the US, even though they do have obligations to arrest him and act on the ICC warrant. So you have those kind of diplomatic contestations going on around the arrest warrants, and then you also have submission, and the investigation by the ICC continuing, but quite difficult circumstances for a variety of reasons, where the chief prosecutor of the ICC is now on leave from his job because of an investigation against him for sexual misconduct within the ICC, and allegations made by other members of staff there against him at a quite serious level, plus a whole kind of range of sanctions that have been imposed by the US and the Trump administration on the ICC prosecutor, on members of staff, on even some of the judges of the ICC, and most recently, as people will be aware, on some of the leading Palestinian human rights organizations who've been involved in making submissions and filing evidence and documentation to the ICC as part of this process. And so, while you have international lawyers and Palestinian organizations calling for more Israeli perpetrators and suspects to be charged, as well as a wider range of crimes, including settlement crimes and the crime of apartheid in the West Bank, which by some reports the ICC has prepared and has a request for arrest warrants for Ben Gvir and Smotrich, particularly for settlement colonial crimes and the crime of apartheid, ready to go, but haven't been filed to the judges yet because of fear of further sanctions being imposed. And so there's a lot of kind of fraught stuff going on around the court there, and ultimately, in the meantime, more atrocities have been carried out, and we're not any closer to any of the suspects being actually brought into custody and prosecutions being able to be initiated. And it's unclear if or when that might be more likely to happen. But as it stands, that's the latest set of updates from there. And then the final point, and I'll maybe just, I won't say, I'll maybe just stop on this and open it up for the discussion there. But I suppose what I would say is that, we can't really rely on the International Criminal Court or the ICJ to deliver justice and progress and transformation in and of themselves. Their processes are slow, are fraught with all these geopolitical contestations and obstacles and interference. And ultimately, even when you do have, particularly in the case of the ICJ, when you have a clear, definitive ruling from the ICJ, it still will be up to member states to enforce it. And so, where the role of individual countries comes in is on one level in pursuing and implementing its own obligations under the international law, rules and decisions that are there. But also we have, possibilities and many kind of interesting and important actions going on and being advanced by movement lawyers and public interest lawyers around in countries all over the world, trying to get the question of Israeli atrocities and Israeli apartheid and Israeli occupation and Israeli war crimes and Israeli genocide in whatever way is possible into the national courts in their own jurisdictions, whether that's filing evidence to prosecutors over members of the Israeli army who are dual nationals, who might be or who are may just happen to be on holidays in their territory, and organizations like the Hind Rajab Foundation doing a huge amount of work compiling all of these files on individual soldiers, Israeli soldiers, and documenting their crimes so that there's evidence there and that can be used for prosecutions in domestic courts. Many cases going on and being filed against governments over their own complicities, failings, arms transfers, and other kind of weapons exports licenses when it comes to Israel, in Britain, in Germany, in the Netherlands, and many jurisdictions there. And lots of lawsuits and cases also been and litigation against corporations and business entities, whether it's arms company and weapons companies, or whether it's the likes of Airbnb or Booking.com or other online platforms that are offering services in illegal settlements and profiting from those enterprises, including some interesting stuff that's been happening in Ireland on that front, which again, if we can talk about if there's time. And the one on the image on the slide there, people may be aware of the case that was filed by uplift and the ditch and some Palestinian plaintiffs against the government over the use of Shannon Airport and Irish airspace for flights and transports, potentially of weapons and weapons components to Israel, as well as some of the dual use exports and looking for judicial review of that. The very first kind of intervention in that case was a letter, a pre lawsuit letter sent to the government back in October 2024. It was July 25 before the case was fully filed in the High Court, and the High Court didn't get around to setting a date for it over the summer period, and then went on its recess and is only back since last month. And I haven't heard, others may be aware of updates. I haven't heard any update yet as to whether there's a date set for hearings in that case. But again, some important and creative kind of legal actions being done by various people close to home and all around the world. And I suppose just to conclude, like all to say that all of these legal tactics and legal actions are important in trying to hold, in whatever way possible, Israel to account, trying to express solidarity with Palestinians through these kind of legal mechanisms. But they're all limited in and of themselves. But where, I suppose one of the key points to think about is how are they being done as individual tactics that are coming together and coalescing in a way that's building a kind of a global kind of strategic response and strategy towards supporting Palestinian liberation. So I better stop talking there, and thank you for listening.
So thank you, John. That was very comprehensive and covered a lot of ground there. So thanks, Mill, for that. We have a bunch of questions, and just to say, we have well over 100 people who are watching. So we have a very strong interest in this. Brian, do you want to kick off on the questions? If not, I can do so.
Yeah. Go ahead. I was muted there. Yeah, go ahead.
Okay. John, Ireland joined the South Africa case at some level. What is the update on what was the purpose of Ireland, or what input did they make? Was it significant, and what's the latest update on that?
Yeah, so thanks for that question. So yeah, as part of any ICJ dispute, which is normally between two countries, and so in this case, the dispute is between South Africa and Israel, but there is the scope for other states who are not directly involved in the case to make what are called interventions in the case. And so sometimes it's referred to in shorthand as joining the case, but it's not that Ireland has joined South Africa and is now a plaintiff or a co-complainer in the case. Ireland, along with a significant number of other countries, have made interventions which is where basically they will say that they have an interest in the case, either because it directly affects them, or in this case more so because they feel they have a legal analysis or a legal argument that's relevant to the case that they want the court to be able to benefit from. And so countries like Colombia, Mexico, Spain, others have done this as well. Ireland's specific intervention was making a relatively progressive argument that essentially that genocide should be more widely interpreted and understood by the court compared to how it was quite narrowly implemented in the Bosnia versus Serbia case. And so, it was trying to it's not that Ireland is taking a side and saying we're with South Africa and we're against Israel in this case, but clearly its argument that it submitted was more favorable to the South African arguments and submissions in the case. But that's then up to the court basically what it does with that. There was a strategy, a kind of a collective strategy in the Ukraine versus Russia case, sorry, where all of the European states decided to file basically almost identical interventions in that case in support of the Ukrainian argument, but the court didn't accept them. It kind of backfired in that the court didn't accept the arguments submitted by the European allies of Ukraine, and decided, as at least in one limited part of the judgment, decided against Ukraine on that. So there's no guarantee that it will have a positive impact, but I think it would. What Ireland's submissions there would broadly kind of align with what a lot of international law scholars and genocide scholars would have said in their criticisms of the narrowness of of previous decisions by the court on genocide. It's not that Ireland has submitted some kind of radical reimagination or claim for the entire, genocide convention to be reinterpreted from a, radical anti-colonial perspective, but it has, within a relatively kind of particular set of parameters, has made a quite specific and niche argument, but broadly progressive, or at least not a terrible contribution. The question then is, if Ireland is willing to support or make this intervention here, there are lots of other things that Ireland can and should be doing to progress and to kind of work towards better implementation of international law. And if Ireland believes the kind of stuff that it says about a genocide here, or about illegal occupation in the submissions it made in the advisory opinion proceedings, or just some of the stuff that the government says generally in its statements about international law, like if it believes all of that, it should be joining the Hague Group. It should be doing much more in terms of its role within the European Union, and also in its bilateral relations with Israel, which we haven't seen. And that's where, I think a lot of people have identified and quite rightly seen the gaps between the rhetoric and the material practices. And, Ireland did send a representative to the Hague Group meeting in Colombia over the summer, but from just by from talking to Palestinian colleagues from social movement groups who were there, they were really disappointed. There was, I think, four European countries who did turn up, but said we're only here as observers, stayed silent for the whole thing, refused to kind of engage or participate really. And this was at the same time that the EU was going out of its way to avoid implementing any sanctions during some of the worst atrocities during the summer. And again, Ireland were kind of acquiescing to that. So I think there's rightly, I think, a lot of frustration and disappointment from Palestinians about how far Ireland has ultimately been willing to go in matching its own statements.
Yeah, exactly. So lots of, well, not lots of, but some rhetoric, but no action, right? Um, a question there, John. You said that many international lawyers would argue that the central bank is subject to the same obligations as government in the case of international law. I guess the Genocide Convention should argue isn't a definitive obligation. So how does that play out in practice?
Well, I suppose ultimately it would have to be tested. Like some of these scenarios are, have not come up before, or at least haven't been adjudicated by courts. And so, there's always like different international lawyers will give you and in the same way, with any area of law, there's always an element of indeterminacy, or there can be arguments made from either side, and it's ultimately then a question of, who's making the argument more persuasively, but also who's the one actually making the decision, and how convinced are they by the arguments they've heard, how much are they bringing their own biases into the decision, and so on. And so, the question of uh, specific kind of sub-state bodies, like um, whether we're talking about local councils and municipalities, or various types of government agencies, or even, this has come up with in relation to the universities and their responsibilities, like universities as public institutions, the question of how far they can be held to account and to be responsible for the international law obligations of the state, is still being figured out through cases and through testing. And so, I think personally, my position would be, as a state body, and as a institution of the state that is involved in activity and relationships that do have a bearing on our engagement with Israel at a time that Israel is committing genocide, that the central bank does have those obligations, because otherwise there would be a vacuum. The state also, there is a question ultimately of the government's responsibility here and the government's um, capacity to intervene and to make a decision. But in the absence of it doing that, to me, it's not acceptable for the central bank to say, well, it's not up to us. We can't do anything. And so, but again, that would have to be tested, and different legal authorities will have, may have different views on it.
Yeah, and just to support that, the governor of the central bank, as we heard from Helen and Sean in the first solidarity session, effectively stonewalled and refused to answer questions at the Joint Oireachtas Committee meeting a couple of weeks ago, and basically said that the central bank had no obligations in terms of international law, which sounds absolutely ludicrous. A similar point is made that the DPP presented in Galway University recently, and she was asked why the DPP has not prosecuted the Central Bank of Ireland, and basically she refused to answer any of the questions or to differentiate between public interest and any unwilling or unable element. Any comment on that?
I mean, I didn't hear that talk, and so I don't know how well equipped I am to answer that question specifically. I mean, I did, because I'm just reading the question there. I know there was also a question. I did see a clip about the relationship, the contract that her office has with
Checkpoint,
with Checkpoint,
which is an Israeli technology cybersecurity company. Yeah.
Yeah, and I did see her answer on that, which was really unsatisfactory, and really just not acceptable, to say, well, we'd have to see if we can get an equivalent level of service from another provider, essentially, that, cybersecurity is important. And so that comes first, or that comes before any question of,
Yeah.
complicity.
Well, it's about 20 more companies can give a similar product, but obviously the DPP is using an Israeli company to provide this service, which is shocking again.
Yeah, yeah, and I mean, even just thinking about, data, the questions about, data security, and we have all of these concerns about the Russian threat or the Chinese threat when it comes to data protection and privacy in Europe. But uh, the idea that it's fine for an Israeli entity to have access seems particularly problematic.
Okay. Brian, is there anyone you want to pick up there?
Let me see.
There's one.
There's two about the media, as a matter of fact, which I know is really the focus here. One is Haaretz and the new Arab Daily are documenting the ongoing slaughter and starvation. Irish media is largely a void. This is the question. Daily letters go unpublished. Should there be demos outside media outlets in Ireland as well? No, that's kind of outside the scope of the thing.
It's not really for John to answer there. I think you could have lots of. I mean,
there is, however, a question here, which is,
I'm happy to just say yes, there should, but
yeah, of course, yeah, of course, demonstrate, yeah.
Here is a question, though, more focusing on international law and so forth. Can you clarify international law regarding journalists and media stations, RTE, BBC, for instance, and their complicity in covering up for Israel amid disinforming the public for a long time, contributing to the genocide continuing? And you could comment on domestic law on that matter as well. Is there any way in which media outlets can be held to account for that kind of thing through national or domestic or international law?
That's a good question. I mean, I'm not, there's definitely a question ethically and morally about the role of the media, and some of their, particularly when we're talking about, the level of disingenuous coverage, the use of, just completely distorting language in a way that, manipulates the story. Whether, like in terms of like specific legal accountability, I'm I'm not sure, and I'm not a media law expert. So again, I don't want to give any false hope there. I think it's definitely worth looking into, and I think where there's clear evidence of of stuff that's been published that is untrue, and where you can identify some kind of causal link to a pattern of misreporting or invalid information, and that kind of shaping general kind of social attitudes, and particularly maybe shaping um, government policy. There could be a way, and I think like I said, there's lots of creative and imaginative lawyers doing this kind of work all around the world, and so it might be worth looking elsewhere. I know there's been some big uh, at least campaigns done around the New York Times, and it's complicity. Again, I don't know whether that's got to the point of kind of legal action against it, but I think every angle is worth exploring for sure.
Absolutely, a very interesting point. Another question here on a different subject. So the Irish taxpayer is reported in the Irish Independent, that was today, I do believe, has to pay a 10 million euro bill for US military flights. What can we do about that?
Um, so I don't know the specifics of that bill, but I mean I think that is the issue that has been that Uplift and the Ditch are trying to pursue through their case and the judicial review. They're asking because the government has initially for a long time been denying obviously that there have been any weapons components coming through on flights through Shannon or through Irish airspace, even though they've been given the flight schedules and the inventory lists and the documentation by the ditch and other investigative outlets. And I think, they've recently kind of ended up having to admit that there are that there are instances of flights coming through with weapons on them. There's the wider issue obviously of Shannon being used as a US transit, a US military transit hub for more than 20 years now, since the time of the Iraq War and the initiation of the War on Terror. And so there are, I think, and this is part of the very important live debate that is going on about Irish neutrality, about where do we stand in the world on these kind of questions, about to what extent do we want to acquiesce to this kind of heightened militarization that's going on in Europe and across the world. And so I think it is I think that case that Uplift and the Ditch have brought is really important. And I worry that they're not going to, that the government is not going to engage and give the kind of information and cooperation that it should. And so then it'll be a question for, how willing is the High Court to compel it to do so. But I think, again, that's obviously, it's not, we as the taxpayers should not be paying for to subsidize US military flights, if I understood, that's what's happening here.
For sure, for sure. That was reported today. I haven't read the article yet myself in full. There's a question here from Catherine. Can you also talk about Palestinian prisoners? What's happening perhaps in places like State Taman? And, there's sickening things happening, consistent reports emerging, and, it happened in specific locations, specific people doing it, and there are witnesses. Is there scope for a case around that? What do you think the likelihood is?
Yeah, so I mean that's been one of the really most distressing kind of stories the last while. On many levels, like what there's so I don't know how closely people would have been following this, but there was this whole kind of scandal in Israel with the military advocate general, who's basically the senior military judge, who was um, accused of, who basically was, from what I understood of the kind of facts, was basically worried that the types of torture and sexual abuse that were happening, and particularly where there was video evidence of it happening in the Israeli prisons of Palestinian prisoners, that that could, and if those videos were circulating, that that could cause issues for not just for the soldiers themselves involved, but also for some of the legal advisors and the likes of, herself and their, their accountability at the International Criminal Court if there's clear evidence that there's violations like that kind of torture and abuse that are war crimes and crimes against humanity happening in Israeli prisons, and then there's no prosecution of the soldiers involved for doing that, then the military lawyers and military judges can themselves be held accountable and could be subject to ICC arrest warrants, for example, right? And so, and this, goes back to last year when, there was the evidence started to come out of the type of abuse that was happening, and some of the Israeli right-wing politicians and settler groups stormed into the prison, refused, started demanding that any Israeli soldier that had been even, accused of or called in for questioning about the abuse that had been happening, that they should be left alone and left to, there was this whole insane debate even in the Israeli parliament about the right to rape Palestinian prisoners and so on. And so all of that, I suppose, was part of the mix where the military advocate general decided basically that, something needed to be done about this. There needed to be an investigation as much as anything to cover herself and her colleagues and to show that they had acted on the abuse that was happening. Because of that, she was then targeted by other parts of the Israeli establishment for for going against the and being disloyal to the army and so on. She was removed from her position, and the person who's replaced her, at least I don't know if it's a permanent appointment, but the person who's replaced her, for now at least, is another official who is on record as making some of the most kind of provocative genocide and incitement to genocide kind of statements since October 2023. And so we have, this completely distorted debate within Israel where, the problem and the issue is about the military advocate general who was accused of leaking the video, who was accused of being disloyal for wanting to have any kind of semblance of accountability, rather than the actual offense and brutality of the assaults and the mistreatment of the prisoners themselves. And those soldiers who were involved in the abuse are being kind of celebrated and romanticized and so on. So there is a question there, I think, about the International Criminal Court and what it should be doing to investigate people involved in that. There also has been suggestions. There was the case that South Africa brought against Israel was under the Genocide Convention, but there is scope for a similar type of case to be brought under the Convention Against Torture, and that is something I think that some lawyers and groups have been thinking about. Is there a state who would be willing to bring a case against Israel at the ICJ for accusing it of torture as well? There's a question about resources and whether that's the best use of time and energy, given that the genocide case is ongoing and hasn't so far produced the type of results that people were hoping for. But again, I would say if it's possible, the more that's going on as many fronts as possible and the more diversity of tactics, the better. And that is certainly something. I mean, the levels of abuse and torture and the testimonies and the stories from the Israeli prisons over the last, I mean, it's always been bad for the last 70, 80 years, but it's been, just really beyond distressing what's been happening by all accounts the last couple of years.
Yeah, John, you mentioned the case taken by the Ditch with regard to Shannon. The Gary Gannon and his legal team took a case against the ICJ, and that was filed a number of months ago, but there hasn't really been any update. I don't think from any response. As I said, from central bank, obviously these things takes time. The IPSC has brought a case via to personal case against Gabriel McLoof, the governor of a central bank. So there's a number of cases ongoing within Ireland. There's a question there in terms of, are there any legal cases of note, of significance that you see taking place in the wider Europe, for example, vis-a-vis the European Commission, or in the name of the EU citizens, or by the European Parliament, giving the EU's various commitments on human rights, international human rights law, etc.
Yeah, so I mean, there's definitely interesting stuff going on around Europe at the EU level. I mean, I know there's like, been petitions and citizens initiatives and so on. It's very difficult from what I understand. Like this will be, we're getting into European Union law now, which is not my area, but from what I understand, it is, it would be quite difficult. Like the idea would be something like a case against the European Commission for refusal to act or failure to act on some of its own duties in relation to Israel. But I think I know there are your EU lawyers thinking about this and looking into this. It's not exactly my area, but I think there are kind of quite specific obstacles there, and the EU law system is not maybe set up to to in the best way possible to hold the institutions themselves accountable. But again, it's not to say that it wouldn't be possible or shouldn't be done. Like one of just on the other kind of cases that have been suggested or coming up. You mentioned the various ones in Ireland there. One that you didn't mention was about Airbnb and the um, um, complaint that was made to the guards, calling on them to investigate Airbnb for essentially for money laundering and under proceeds of crime legislation, which some people may not be aware of this, but the Global Legal Action Network and others have been doing some interesting work on this. And basically, the argument is that Airbnb and outlets like that are engaged in activities in illegal colonial settlements. They're generating revenue and profiting from that money because of Airbnb's um, Irish subsidiary is where a lot of that revenue gets booked. That essentially, because settlements are criminal enterprises under the Geneva Conventions, that this is essentially proceeds of crime, money that's been laundered through Ireland, and the guards should investigate it. Right? Obviously, that legislation was set up originally and intended to deal with organized crime and kind of mafia related and gang related activity. But again, it's another example of using the law creatively in a way that might not have necessarily been part of the original intention. The guards refused to or declined to investigate, said this wasn't, there was no specific offence within the jurisdiction of Ireland. But the High Court last month has basically overruled the guards' decision there and said that that was not the correct decision, and that they should pursue an investigation, because there does seem to be the offence within the jurisdiction is the money coming through Ireland. And so there's that's up to the guards now, as I understand it. It's back to them to act on the basis of the material and the evidence that they were given, and to investigate that. And that's it. I think of it because that's what's been happening in relation to Airbnb in Ireland. But there are cases going on against Airbnb in France, against Booking.com in the Netherlands, and so some of those corporate entities involved have been challenged. Again, these are small and isolated kind of instances, and it's not the same as holding the entire machinery of the European Union responsible, but it's the type of thing that is going on and can feed into then a push upwards from there. I think there was a couple of questions about the Occupied Territories Bill as well that I just saw coming in there. I don't know if
Yeah.
Absolutely. I'll read a few of them out. One here is Spain has implemented a similar OTB, so why are we so scared? There's another question which is straying off a legal point of view, but it's still a very good point. Hi, John. This may not be an exact legal question, but what is your view on some noted people's view that the passing of the OTB would have no real effect, and that Ireland would be made to suffer economically in terms of foreign direct investment from the US, and otherwise perhaps meaning US anti-boycott laws? Are they trying to defend the indefensible, or is there a real concern? What would you say to that?
Yeah, so I suppose they're related questions in the sense that part of the reason we are, or the government is scared, is because of this fear mongering from the US. And I Yeah, I see another question there from Maeve Higgins about how, how can the Irish government submit the genocide case and also refuse to pass the OTB? And again, that's back to the disconnect and the major gap between what the government is saying on some cases and what it's doing on others. And so, there is this obviously kind of concerted and organized campaign from the US and some of the pro-Israel groups in the US to suggest that, that passing the Occupied Territories Bill will have this, massively detrimental effect on US investment in Ireland, and that US companies will be brought, into problems with the law in Ireland that will conflict with their obligations in the US. But I mean, I think that this is hugely overstating and exaggerating the situation. The vast majority of American companies who are operating in Ireland have nothing to do with settlements or occupied territories in Palestine, and so it's only a quite small and specific number of companies who are doing that, and they're doing that in breach of the law, of international law, and of what would be Irish law incorporating our international obligations. And so the question about would that conflict with US anti-boycott laws, like the main anti-boycott law, the main federal anti-boycott law in the US is not specific to legislation dealing with, or policy dealing with occupied territories. It's about boycotting Israel as a whole, which the Occupied Territories Bill is not doing. We could say that, we should also have legislation going in that direction, but that's not what the Occupied Territories Bill is doing. And so again, I think it's misstating and misrepresenting the reality as part of a campaign to try and intimidate the government. It's part of this wider kind of scaremongering that's been going on about the decline of Ireland's reputation because of its in the US, because of its policy on Palestine, which again I think is suits a certain kind of pro-Israel agenda, but is not really reflective of the reality for the most part.
Yeah.
Absolutely. And it's a handy excuse for politicians who really didn't want to do anything anyway.
Yeah, exactly. Yeah, and I mean, there is, like, ultimately, like, taking a moral position on something, there may be, that will come with that may come with, certain relationships or certain consequences being affected. But it's ultimately a question of what are our priorities as a society, as a state, and there would, if I think the relatively minimal impact, if any, economically, has to be thought of and put against, the question of, the moral and legal and ethical imperative of stopping a genocide, which, you can't put any cost on, really.
Absolutely.
Exactly.
I have a follow-up question from myself. The government, again, because I think it suited them at the time, last summer cited the ICJ advisory opinion, I do believe it was, as a game changer, as a reason why now we're going to have to do the Occupied Territories Bill. This was, a few months later, they were making pre-election promises to implement it, But was that a game changer, the ICJ advisory opinion, in terms of the
Yeah,
Occupied Territories Bill? I mean,
yeah,
so
so it's a good question, and I would say, like, legally it wasn't a game changer in the sense that the ICJ advisory opinion, especially when it came to question about settlements, did not say anything new. It only just confirmed what was long established kind of principles of international law, that the settlements are illegal, that third states have responsibilities not to in any way aid or assist the settlements. when the bill was first presented by Francis Black in 2018, I think, into the Parliament, had been discussed for a year or two prior to that. And, I wrote a short legal opinion with a colleague, Tom Morenhout, at the time in 2018, just setting out what are the legal international law obligations around this. And, there was no question really that um, settlements are illegal, that therefore trading with settlements is a form of prohibited aiding and assisting of settlements, and so that would be imperative on all states to prohibit that. And so, l- as I said, legally it wasn't changing anything, but it was a convenient way for the government to say, okay, well, we're under pressure from the public and from society and the opposition to do something. So we've come up with all these various ways, the money message, various other technical obstacles installing, removing it at the last minute from the program for government in 2020, all of these kind of ways that the government had avoided for 6 years prior, implementing it now felt, okay, this is one thing we could do that will keep people happy, that might get us re-elected or whatever if we say we're going to do it. So they were, able to say, well, now there's a game changer and we can uh,
And your excuse for not doing
go
anything
ahead.
all along.
I,
Yeah,
I do think politically it was a game changer in the sense that it gave a lot of states, um, who were trying, who had been hesitant or reluctant or hiding behind uncertainty. It gave them cover, and anyone who was serious and wanted to go ahead, and Spain and Slovenia and others have done that now. It gave them, the grounds to do so, but they could have done so and should have done so, many years before.
for sure. For sure.
Yeah. One question there, I think, expresses some of the frustration we all feel. And I think you said at the start, John, you're not you see the limitations of international law and the frustrations involved in it. And but basically says surely whatever rulings come from the ICJ or the ICC are irrelevant, as the US and Israel don't recognize either, and colonial powers won't act against the US and Israel. Also, the courts have no powers to implement any rulings. So I suppose that's just expressing the frustration we all feel. Any comment on that?
Yeah, I mean, I totally understand the essence of the question and can relate to that. I wouldn't say they're irrelevant in the sense that, okay, because even if we take it at, what does the judgment say on paper, and does the court itself have the power to enforce that directly? No, it doesn't. So, okay, there's an element you can say it's irrelevant there, but the as I was trying to say, it's ultimately is up to, those documents, those decisions and judgments we have from an international court are the value of them is how they're used and how they're mobilized by states, but also by activists, by lawyers in other jurisdictions trying to bring cases locally and all of that. And so sometimes they can have a ripple effect and have an impact and become relevant in ways that we didn't expect them. Or, we can think about it. It's up to us, or it's our role to make them relevant if they're not automatically being complied with. And just I suppose there is a couple of distinctions or nuances maybe just to highlight as well. The US and Israel is not a member of the International Criminal Court and refuse, are saying they don't recognize or accept the ICC's jurisdiction over Israel or Israeli officials. But they are members of the International Court of Justice, and they do, recognize that and have, obligations there to a certain extent. And the US, there is a US judge on the International Court of Justice, who'd just been there since last year, but the previous US judge before her was the president of the court at the time of the very first provisional measures ordered in the South Africa case, finding plausible genocide. So, it's not necessarily as easy when it comes to the ICJ for the US to completely go after it in terms of delegitimizing it or sanctioning it or so on. And the ICC, like, the problem with the difficulty and the challenge, the obstacle of the ICC is getting Netanyahu, for example, into custody. Once the once the suspect is in custody and the trial proceeds, if there's a guilty verdict, then they're in custody in The Hague, they will be imprisoned and serve a sentence there. And so, it's in some ways a different type of problem with enforcement to the ICJ. The ICJ can have the strongest opinion and ruling in the world, but if the state refuses to accept it, it's not the ICJ can't do anything further to enforce it. It's up to the UN Security Council, and we know the problem there is that the US has the veto. Whereas, if you can get to the case to the scenario where you have the person in custody, once you then have a judgment, that judgment will be applied and enforced because you have the apparatus in place around the court in The Hague, and the person will already be in custody at that stage.
Sure.
But obviously, getting them there in the first place is the
John, there's a question there on universities. In terms of if a university has commercial ties with an Israeli company based in Ireland, a university in Ireland has a commercial relationship with an Israeli company, what would the legal implications be? I think, for example, the protest in UCD, obviously there was a very successful protest in Trinity, but in UCD there is a high-profile company, Techion, who are providing military equipment, and UCD, or a company with part of UCD, has a relationship with them, and there's been an ongoing protest down there. Specifically with regard to universities, any comments on that?
Yeah, so I mean, well, this is the kind of stuff we're working on a lot with academics for Palestine, and it is in like the obviously the encampment in Trinity had a particular leverage because of the Book of Kells and was able to get concessions from the university on that front. But it was interesting that the university did also, in agreeing to make commitments about divesting from Israel and not having any future academic partnerships and so on, it did refer to and reference the International Court of Justice decision now in a general sense, and not saying directly we are doing this because we have legal obligations to prevent genocide under the Genocide Convention because the ICJ has said so, but indirectly at least they did acknowledge that, and one of the things that law professors in Europe particularly have been doing is trying to advance this argument that the universities, and particularly public universities, are also public bodies with obligations. And there's a group in Antwerp who've done a lot of work on this and produced a legal opinion on it, that again, these are new, this is new kind of terrain, and we're trying to advance the best possible understanding. But there is, I think, certainly an ethical obligation on the universities, and potentially also some legal responsibilities there. The Technion, just to be clear, is a university institute it's a third level institute in Israel that has a lot of projects and interactions with the Israeli security sector and the Israeli military economy and so on. And Technion is part of these partnerships with UCD at the moment, but also with Galway. And there's that has caused obviously a lot of contention internally within those campuses, especially because these are new partnerships that have been signed post genocide, let's say post 2023. Not that we academics for Palestine and other groups have been arguing for many years before 2023 that these partnerships should not be established and maintained while there's an illegal occupation and an apartheid regime and all of the other forms of oppression of Palestinian rights. But obviously the imperative has become clear to many more people, including some university management and administrators, since October 2023. And so the fact that these new partnerships have been coming on stream, and there's question marks over whether they in the Galway context, particularly because Galway had made commitments to be an apartheid-free campus and to have a human rights impact assessment on any new partnerships, and so there was question marks over whether that was actually followed in the signing here. And so there are lots of good and important work being done by student groups and staff groups, and including now some legal advisors looking at some of this. And this is, I think, at least having the spotlight on this, and the universities being in the uncomfortable position of having to justify their decisions on this, whereas 10 years ago they were able to kind of ignore any criticisms over this. Now they are, this has become much more of an issue for them, and some universities are taking it more seriously and are more genuine about it than so far than others have been. But um, yeah, I think it's again another important kind of pressure point for campaigns.
Yeah. There's three questions there which I'm going to pull together into one. One relates to the Hague Group, which we mentioned already. Would Ireland joining the Hague Group be effective, or whatever? There's also a question about United for Peace, which is an initiative within the UN, basically to basically get away from or try and get around the Security Council basically blocking any decisions. And a similar question: what would be the pathway to ending the vetoes of any one member of the UN Security Council? Right. I'll leave that with you, John. Nice, easy question.
Yeah, well, maybe take them in reverse. Like, this is something that I talk about with my students a lot, and it comes up like, as anyone who comes to international law new, and it's just learning these structures and learning all the nice rules and principles and the way things should be, and then you get to talking about the enforcement issues and this catch-22 situation that we always end up in with the Security Council veto, and there's no good answer to it in the sense that it's obviously a massive democratic deficit and a massive obstacle to more progressive possibilities in the UN. And a lot of my students just can't get around their head around it. Why would the legal system have tied its own hands in this way? But that was the historical compromise that was made after the war in 1945. And the problem is obviously the five permanent members who have given themselves that veto power. Like, the only way to remove it is for them to, for a Security Council decision to do that. And so they would have to go along with it. There's been all sorts of various proposals going back to the 70s, 80s, and 90s about some limited, partial kind of tinkering around the edges reforms of the Security Council, like to make it that it's not Britain and France, but it's the European Union has a permanent seat, or Germany and Japan should be there as additional permanent members in recognition of their contributions to the UN budget, and because they, are totally different countries now to what they were as they were trying to get away, or transition out of fascism after the war, and excluded for that reason. So, but there's it's very difficult to see in the short term, at least, the appetite being there. There's been lots of really good, interesting proposals for reforms put forward going back to Kofi Annan's time as Secretary General of the UN, and many other suggestions for how African representation, Latin American representation, etc., should be strengthened in the Security Council. But as it stands, it's really stuck in that kind of catch-22 situation. Because of that, then there are these calls for uniting for peace as a kind of a way to bypass a Security Council inaction. I suppose the question is, what are we talking about? What kind of initiative are we talking about? Uniting for peace being used for, because it has, uniting for peace as a process has been used a number of times by the General Assembly in relation to Palestine, including in recent years. And there's the request for the very first advisory opinion on the illegality of the wall back in 2004 was kind of pursued under an emergency session that was set up by a Uniting for Peace process. And even some of the earlier um, General Assembly resolutions on the ceasefire, calling for a ceasefire, in the early months of the genocide, were also being adopted under Uniting for Peace, as far as I understand it. So, the question of there's there's not really an obstacle to the General Assembly issuing resolutions and giving its position on things like there should be a ceasefire, or there should be, calling on Israel to withdraw from Gaza, or whatever it is. The question then is, if we're talking about deployment of peacekeepers, for example, or something at that level, if you have a General Assembly resolution doing that, is that you're still going to have the buy-in and the legitimacy of any member states who are going to who are going to contribute to that. And now we're in this tricky situation where the US is trying to use the Security Council to for its own ends and to impose its version of this neo-colonial peace plan and the quote unquote kind of stabilization force and the Board of Peace and all that, and is coercing a lot of the other states, including some of the Arab states who are going along with that.
John,
so
I'm conscious that we've gone well over an hour and a half, so you've been extremely generous with your time. I'm just going to take one final question, and it relates to the first session we had on the central bank. So our Taoiseach leader, or whatever, of the country, whatever we call him, Micheál Martin and Simon Harris, both referenced that Israel is perpetrating genocide against the Palestinian people. The ICJ preliminary ruling said the same. The UN said the same. So the evidence is indisputable. Yet the organs of the state, including the executive, the government, have taken no action whatsoever. And it would seem to a lay person like myself that this is the most extreme contradiction, that we say one thing and we do nothing. And even the government, the executive, Pascal Donoghue said that the ICJ is a separate body, but the government can't tell them what to do, etc. Whereas they do have the powers, and that's been clear from the discussions on the central bank. Surely a massive contradiction, a massive frustration, and any comment on that?
Well, I suppose just to agree with you, really, Tom, yeah, I agree absolutely. There's a massive contradiction. There is an imperative, I think, both on the government as well as on the central bank itself. There was obviously a lot of uh, positive feeling initially when there was this announcement made about the transfer to Luxembourg, and the assumption that was because there was some form of active decision and intervention from the Irish state to refuse to handle the Israeli bonds. But as it transpires, and people probably are aware of this at this stage, that was a decision made by Israel itself. I do think, but from what I understood from some of the reports in the Israeli press, the Irish government and officials had been asking the Israelis about, where is the money from these bonds going? Is it being used to fund genocide? And obviously the Israelis just didn't want to know about that or have to answer that. And so that may or may not have been a big or small part of their decision to transfer it. But as people probably know, that transfer does not abdicate Ireland from its responsibility. Ireland still is the home state, and it seems that because of the particularities of the way this happened with Britain previously being the home state, then because of Brexit, it moved over to Ireland. But normally you can't transfer. There's only one home state for the lifetime of the bonds, and so it is up to Ireland. Does have the power and the capacity to refuse to issue the bonds or approve them. And that's, I think, potentially a significant decision that's going to have to be made, I guess, next September. And so I think, again, it is important for people to be as familiar and aware of the situation as possible, and building towards that, from not just next August, but in the long lead into that, to put as much pressure as possible on the government and the central bank in the meantime.
Yeah, there was a question about some questions around, how can we work together in terms of how can civil society and activists and legal entities work together. I think the central bank has been a very good example of that, where a lot of activity in the Dáil, in the Seanad, with political parties coming together, with activists coming together, with demonstrations, with legal actions, etc. And I think from your previous presentation, I don't want to ask you to give a long answer to this one, but I think what you've said is, look, legal entities and cases can do so much, but civil society also needs to act and keep pressure on the government and keep pressure on entities like the central bank. So I think all the different strands need to work together. Would that be? the
Yeah,
case.
absolutely, absolutely. And I suppose what I would say is just especially for people that are new to the movement and came with a lot of energy and enthusiasm, and then obviously get, you do get beaten down pretty quickly by how, all of the work and all of the, obvious things that should be happening that are not happening. So I suppose what I would just try and emphasize to people is that, this is a long haul kind of struggle. The Palestinians have been fighting for their freedom for, 100 years and more. We know how long it took, and is only partial still in terms of our own context here. And I think like as you said, like the kind of coalescence of activism and the regular demonstrations at the central bank and all of the energy around that over the few months over the summer, plus the intervention from the lawyers and the legal letters that were written, plus the stuff that was going on in the the Oireachtas committee and the interventions, including from Palestinian speakers and stuff there, all of that energy and kind of overlapping and intersecting work was, as much as I was saying, like it was a bit of a fudge and a deflection by the government, it still was, I think, a not insignificant uh, victory, at least, initial victory, provisional victory for the movement, that those, uh, however ultimately the decision was made, there was a decision made, and people should be, should take credit for that, but while kind of recognizing that there's still, a lot more that can be done and needs to be done on that front, as well as on the many other fronts. And even, just thinking about the Occupied Territories Bill, which again, it's insane how long it's taken to get from where it started 7 years ago to, still not being over the line now. But again, all of the work that's, people, I think, rightly will question, like, is that the most important measure, the most effective measure? Probably not, but it's one among many, and it's something that there has been a good energy that's coalesced around, and there's been a huge coalition of civil society organizations, and not just the Palestine solidarity groups, but all of the major kind of trade unions, human rights organizations, and other groups, as well as stuff we were doing, including with the IPSC and I was in there with Fatin in the Oireachtas committee over the summer, and all of the other work that's been going on by policy people and policy people, on the legal side and all that. And there are, people, understandably do want, are outraged and distraught about what's been going on in Palestine, want to contribute, and these things, these kind of movements do take time. But I think, certainly, like, if we think about, the legitimacy of the Israeli state now compared to, when all of us started working on this, and the changes that have come about. And obviously, it's terrible and tragic that it takes a genocide for some elements of the state apparatus, or of official institutions, or of the media and so on, to wake up. But that, that has been happening. And even just thinking about the opposition bill now, or the opposition motion for the Occupied Territories Bill on Wednesday, and kind of just having that energy from the movement pushing the opposition to work together, on the back of the, successful kind of unified left campaign in the presidential election. There is momentum there, and it's up, I suppose, to everyone to kind of figure out the best way that they can contribute and be part of it.
Yeah. Okay.
Very cool.
We'll leave it there with regard to questions. So thanks a million, John. That's been amazing, and you've been very generous with your time. Thank you, Brian.
Thanks for having me.
And I would ask, and thank you to everyone who has been on tonight, and who will, the recording will be available up on our YouTube website shortly, as soon as we can get it up there. So there's also ongoing protests. There's one on Wednesday at the Dáil, 5:30. As John said, there's a national march coming up also. And I just want to draw your attention to next week. So next week we have same time, same Zoom link, etc. We have Dr. Rebecca Heslin, who's a clinical psychologist and activist who is committed to bringing themes of power, justice, and solidarity to the fore of psychological practice. In her work, she bridges clinical insight with political analysis and firmly believes that psychology as a discipline has a role to play in liberation struggles across the globe. Now, it's called Solidarity as Practice, Psychology, Power, and the Struggle for Palestine. It sounds intriguing to me. I have no idea really what it's about, but I am intrigued, and it sounds really interesting. So I'm certainly looking forward to that one. So again, I'm going to thank everybody, and thank especially to John. That's been great. And John, we'll keep in touch. We'll see you soon, and keep the struggle going.